am Janice Mattingly at Carmel Family Law, and I am here with Natalie Snyder. She's an attorney here in Carmel who also is collaboratively trained and does collaborative practice. And I am really, if you've been watching any of my stuff or looking at my website, I've been really trying to push collaborative in 2020. It's kind of my clear vision for 2020 for my practice, because it's something that I've done off and on for many years, but it's really something that I'm just really focused on in 2020. So I've invited Natalie here so she can share her experiences with collaborative. So Natalie, will you please introduce yourself?
Sure. I'm Natalie Snyder, a family lawyer at Cross Glacier Burroughs in Carmel.
And how long have you been doing collaborative law?
So collaborative law, probably, 6 or 7 years. And I'd say trying to get cases to go that way so that we can sort of get more people engaged in the process, because I really think it's the best process for family law.
And they've heard me tell about collaborative practice in my videos, but from your perspective, how do you introduce it to your clients?
So a lot of times I explain to them that there are several different ways that you could go through a family law case. One is the traditional litigation route, which is the more adversarial route. You could also enter into an alternative dispute resolution process, which would be more your traditional mediation, or perhaps even having your case decided by an arbitrator through arbitration. And then there's the collaborative process, which is different from either of those. A lot of people think that collaborative law is similar to mediation, but it really has a lot of differences than just your traditional mediation, which we both do as well.
Yeah, we do that.
So I try to explain the three processes, and then I try to explain to them what the benefits might be of a collaborative case.
And what are some of the benefits of doing collaborative divorce or collaborative law in
Right.
family law cases? It can be guardianships, probate, anything related can be done collaboratively, but what are some of the benefits of that?
And I like to say it's the healthier way to go through a family law case. 3 big benefits that come to top of mind right away is that it's an open process. So sometimes my clients, they get a little nervous because they don't have the formal discovery process. But in my mind, it's an even more open and honest dialogue. There's not supposed to be any hiding the ball. It's a process where we come to the table, we determine what we need to know, we explore what we need to know, and then we go about gathering the information and the facts that we need in an open dialogue, versus if I send you discovery, if I don't ask the right questions, I may not get the right information, and you're not doing anything wrong, you're following the process, but it's a lot more open of a process. And so I always tell people, don't be afraid of coming into the collaborative process, even if you feel like you don't know everything about your family situation, because that's the perfect process for you to be in, to explore and find out what you don't know. So I think the discovery process you can get through quicker, you can get through more effectively, and it can be more of a trust building exercise perhaps than the typical litigation process of discovery. Secondly, I would say timing is a big advantage of collaborative law. We both know the regular litigation track. I think the estimate is it takes you a year to get through your divorce. If you're in the regular litigation track, you have continuances because attorneys aren't available, you have continuances because parties aren't available, courts aren't available, and you're really subjected to their schedule, which is a slow process. It takes 3 months to get a hearing, 3 more months anytime you have a setback or a continuance. And so that year average is
time to get the order.
Right, and
If you
then
have a hearing,
right,
then the judge has
once
time
you
to
have
get
a
the order.
hearing, everybody thinks, well, that's it. You hold on to this date and it's finally done. But no, a judge has 90 days to issue a ruling, and oftentimes they take that entire time. So even after your year, you're still not done, you're still not finalized and able to move forward. So we set up a series of meetings on our own schedule, on our own timeline, and you are able to get through the process a lot quicker if that's one of your goals. It also feels more comfortable to people because they're used to using their own schedule and setting meetings. They're not used to having to wait on a court or a judge's schedule, which are overcrowded and oftentimes get bumped for other things like criminal matters or jury trials or things like that. So I think there's more of a comfort in controlling your own process and how quickly you go through the process. We can also slow it down for people that might need a little more time to process everything that's going on for them. But then again, you have a lot better hand in the process and how you move through it versus feeling like you're just in this litigation model and you don't have a lot of control over the timeline. So time, discovery, and openness, and then also when I say it's a healthier process, people can bring to the table some things that you can't in a litigation model. So you might really need your co-parent or your soon-to-be former spouse to hear something, to get something off of your chest, to talk about something on an emotional level before you can get down to turning on the other side of your brain and the financial side of your brain and making it act more like a business deal if it's a divorce. And so the collaborative process can give you some time to do that and to lay that on the table before you turn immediately to the financials. I also think it's healthier for children when children are involved.
I agree.
Because you're able to openly talk about what your children's needs are, what your goals are for your children, how do we meet those needs. And most parents will say when you go through the process, what do you want your children to look like in 10 or 20 years? And a lot of times they have some of the same goals, but when they get so wrapped up in the litigation model, it becomes more of a battleground versus, okay, we have the same goals for our children, and so how do we put a plan together that ultimately will meet those goals? And you can bring in mental health coaches to help you communicate with each other, to also help you communicate about your plans for your kids. They can bring in a lot of mental health points and things that you can consider or should consider as it relates to kids, to try to keep that focus there and not so much in the adversarial vein of things. And I think when you have a say in coming to your own resolutions, not that you're always going to like everything, but I think you're going to walk away from it feeling a lot better than just having a judge mandate what's going to happen to you and your kids and your finances. So I feel like ultimately your satisfaction level is higher when you can go through the process and have some say in it the whole way versus when you're in the litigation model, it feels very much like things are just happening to you and you're being told, well, this is the next step, but you're really not being actively engaged in that process the whole way.
And I think that's a great point because a lot of times when we talk about this litigation track, if somebody doesn't like the end result, you may feel like you won in a decree. The judge did exactly what I want him to do, which never happens. But even if it did, the other side might appeal it, and that may add another 12 months and $20,000, or the other side will get their pound of flesh one way or another. I always tell people, be careful what you ask for and what you wish for, because if you get it, you may have then a contentious relationship for the rest of your kids, young, if they're young. And the other thing, I like what you said about discovery, because at the collaborative table, we can bring what we call hearsay evidence in. We can bring, well, if we have this person, this is what somebody told me, well, that would not be admissible in court, but at the collaborative table it is, or medical records, or without bringing those professionals in, or without bringing every single witness in. So it saves a ton of time, which equates usually to saving a ton of money. But even if it doesn't save money in the divorce process, like what you said, is that you are happier with the result, so that it tends to then reduce the litigation going forward.
Right, and I think that that's a good point, and sometimes I tell my clients what you just said, that even if you get the result you want out of a litigation battle, then does that mean that your now former spouse is going to not maybe directly tell your children about that, but it's going to feed into the rest of your co-parenting relationship, and they're going to feel the effects of one parent feeling like they won and one parent feeling like they lost, and that may not be the easiest thing to go forward with if you have children, especially. And the other thing with collaborative, if you do have children that are young that you're going to have to raise for a long period of time, or even a series of years, if you've come to the collaborative table and resolved your divorce, as issues arise, and we know they always do as your kids age, you've set up to be able to come back to the collaborative table and hopefully work through those things as they come up in still a collaborative setting versus going out and litigating. And ultimately, you're doing a huge service for your children when you do that, because we both know the number one predictor of if your children are going to be successful and have the least impact of your divorce is if their parents are able to collaborate and cooperate and keep the conflict down as they raise these kids together. And really, if they know my parents were able to sit at a table together and talk about me and figure things out, then they're going to have a good feeling about their parents being able to do that versus knowing that their parents went to court and had a huge battle and now nobody's particularly happy about that.
Yeah, I think that's exactly right. And you mentioned the coaching, the child specialist or the divorce coach or the mental health coaches that come in. I find those so incredibly important in the collaborative process, because they really help the parties come to the collaborative table, like you said, making a business decision with regard to their assets and their debts, and taking the emotion out of it, and helping them to come really prepared to make good decisions. And as lawyers, we are not really wired to make somebody get rid of that emotional baggage. We can't identify it always, and we can't get through it. But those professionals really help the parties come to the table ready to make good decisions.
Absolutely. And if you say, well, I always shut down, I've never been able to communicate my desires to my spouse, and so how could I do that across the table? You're going to have a coach that is going to work with you in advance to know sort of the triggers, to know the pattern of communication dynamics, to know what to look for to help you through that process. So if things start going back to the communication patterns of the marriage that didn't really work and maybe part of the reason why you're here, they're going to be able to issue spot for that and say, you know what, we talked about this and this is how you're going to relay your message to your spouse, or they're going to help you be able to communicate in a way that hopefully is effective so that your voice can be heard, and you are part of the process in the collaborative process. And so it's helping you, which gives you then skills to go on and to continue to co-parent with that person if you have to, if there's going to be children involved, that you're learning skills that you're going to need after your divorce is over anyway.
Excellent point.
And then from the financial side, the financial coach is helping you budget, is helping you think about what your needs are going to be now in the future. These, and so they're very helpful because, again, we can do some of that as attorneys, but that's really not our role. And so having an expert that can really hold your hand and walk you through a budget and walk you through projections on your needs now and in the future, I think there's a lot of buy-in, added value to that process as well. So hopefully when you get out of your family law situation, you've learned some communication skills and you've also learned some financial skills, all within the process of getting divorced, which hopefully then will help you feel more empowered after your divorce. Right?
I completely agree. I think it's just far and away the best way to do it. And I really hope that more and more people in our community do the collaborative divorce, because there's lots of us in the Indy, Northside, Carmel, Hamilton County area that do it. And you have to have both lawyers have to be collaboratively trained, but there's plenty. you
Right.
know, there's so many of us, and so many of us that have done it and do it well, and can represent people well. So hopefully we can spread the word
Right.
and get this done. So
Right.
Natalie, what's your contact information?
So my phone number is 317-582-1040, 582-1040. And then my email is nsnyder, SNYDER, at CGB, as in Cross Glacier Burrows, lawfirm.com. So CGB Law Firm, all together, and then .com. And I would be happy to talk to any of you more about collaborative.
Absolutely. And if you need to reach Natalie and you can't find her, email me and I'll send you over to her. So thank you very much, Janice Mattingly, Carmel Family Law. Thank you.